Hello, everyone. Thank you so much for joining us today. My name is Liz Woodruff, and I'm the director of the Idaho Academy of Family Physicians. We're very happy to sponsor today's presentation with Kim Stinger, an attorney at Holland and Hart, on Idaho's abortion laws, a practical guidance for physicians and other healthcare providers. This is the second in a series that the IAFP has sponsored, starting in December with information specifically about EMTALA. And now Mr. Stinger will provide this presentation today since we have a decision from the Idaho Supreme Court and discuss the interactions of EMTALA and state laws, as well as provide more detail about the status of current state laws related to abortion. This is not a continuing legal education credit or a continuing medical education credit, but we do believe you'll find this information very helpful. Today's event is being recorded, and that recording will be available on the Idaho Academy of Family Physicians reproductive health page, which I'll share information for in the chat shortly. We're also joined today by Dr. Kylie Cooper, who is a maternal fetal medicine physician at St. Luke's in Boise. Dr. Cooper will share a few remarks after Dr. Stinger's presentation and be available to answer questions that are most relevant to clinicians from a clinical perspective. If you have questions during today's presentation, please use the chat box to type in your questions. Mr. Stinger and Dr. Cooper will save time at the end to answer questions from the chat, which I will read at that time. Shortly, once the presentation begins, I will drop in the chat a link to a set of resources. And that document will have all the links that Mr. Stinger is covering in today's presentation. So you'll want to be sure to click on that, keep it open in your browser in order to access the variety of links that will be shared as resources during today's talk. So thank you again for being here, and I'll pass it over to Mr. Kim Stinger, attorney at Holland and Hart, to cover today's topic. Thank you, Mr. Stinger.
Thanks, Liz. I appreciate the opportunity to speak on this important topic. As a preliminary matter, we have provided you with a bunch of resources, including copies of the most relevant Idaho statutes, the cases that have come down from the Supreme Court and the Idaho Federal District Court, along with a bunch of articles that I've written on the abortion issues. A big disclaimer here. This represents my best guess of where we're at. As we talk through these issues, you'll see that we haven't got a lot of clear guidance. A lot of Idaho laws are conflicting or overlapping. And so I'll give you the best guess of where I think we are, but I can't guarantee that a prosecutor or a judge would agree with me. So with that said, by way of background, it will help us kind of understand where we're at if we understand where we've been and how we got here. From its earliest days, at least according to the Supreme Court, Idaho has limited abortions, but then came Roe v. Wade in 1973, which of course held that a woman has a fundamental right to have an abortion dependent upon the particular trimester. In the years following Roe v. Wade, Idaho passed a whole series of abortion laws in response to Roe v. Wade, or in some cases trying to circumvent it. A lot of these laws were passed to either test Roe v. Wade or to trigger if Roe v. Wade were ever overturned. So there are a bunch of abortion laws, different abortion laws on the Idaho books. Now, the problem is that a lot of those abortion laws, they would pass a new law, but wouldn't necessarily repeal the existing law, or a particular law was held to be unconstitutional, but it was never taken off the books. And so we have this whole set of abortion laws that don't always play very nicely together, that don't coordinate and may overlap. For purposes of today, the ones that are the most important are in 2020, the Idaho legislature passed the total abortion ban. It was triggered if the Supreme Court overturned Roe v. Wade. In 2021, a year later, the Idaho legislature passed the fetal heartbeat, or what the Supreme Court referred to as the 6-week ban. It is triggered if the federal court upholds a similar law, but it depended, the criminal penalties under that fetal heartbeat deferred back to the total abortion ban. So if the total abortion ban were held to be or upheld, then the total abortion ban would trump the fetal heartbeat law. In 2022, the fetal heartbeat ban was amended to add some additional or expand the scope of these civil liability laws, basically to add a Texas-style private cause of action for certain family members. Well, that's kind of where we were at the time. I think my theory is that the legislature passed a lot of these laws, never thinking that they would really take effect because they never really dreamed that Roe v. Wade would be overturned. But then came Dobbs. In June, Dobbs v. Jackson Women's Health, the United States Supreme Court held that the United States Constitution does not contain a fundamental right to an abortion and that states may regulate abortion. The practical effect of it was that suddenly then all of those laws that had kind of been out there either were going to be triggered or had been languishing or had been determined to be unconstitutional. Suddenly they all sprang back into life. And we have these kind of conflicting regulatory scheme or statutory scheme when it comes to abortions. The ones that are the most important for purposes of today, again, the total abortion ban or the fetal heartbeat or 6-week ban that contains both criminal penalties and civil liability penalties. The fetal heartbeat statute, the criminal penalties are only applicable to the extent that they were not preempted by the total abortion ban. I'll talk a little bit more about that later. But these aren't the only abortion statutes that are on the books. There's still the pain-capable 20-week abortion ban. There's certain abortion requirements that have existed for years. There's the partial birth abortion ban. There's chemical abortion bans. The Supreme Court did not address all of those other laws in its recent decisions. So those are out there. It's not really clear how a lot of those interact with the total abortion ban. They're probably going to be effective to the extent that they're consistent with the abortion ban. In last August, the Department of Justice sued the state of Idaho, claiming that the total abortion ban violates EMTALA. EMTALA requires hospitals to stabilize patients who come to the emergency room at the hospital. The federal district court concluded that yes, in fact, at least on a preliminary basis, it appears that EMTALA does preempt Idaho's total abortion ban, and therefore the district court entered an injunction, a preliminary injunction, staying enforcement of that total abortion ban in the case of if EMTALA applies. Now, note that that's a preliminary injunction. We haven't got the final decision from that case. That case is still wending its way through the district court. But in the meantime, however, that total abortion ban is stayed when it comes to EMTALA cases. On January 5th of this year, the Idaho Supreme Court upheld the total abortion ban, the civil liability portion of the fetal heartbeat ban, and the fetal heartbeat ban to the extent it doesn't conflict with EMTALA, or it doesn't conflict with the total abortion ban. Basically, the Idaho Supreme Court said that when you look at it, Idaho's outlawed abortions from the beginning. There was no fundamental right to abortion when the Idaho Constitution was ratified, and therefore its job was simply to interpret and apply the law consistent with the Constitution. Since there was no fundamental right to a constitution or to an abortion under the Idaho Constitution, that allowed the Idaho legislature to regulate abortions. Ultimately, the Idaho Supreme Court said that its job is not to make policy or to rewrite laws, that if the people of Idaho want to limit or change the laws concerning abortions, then they have the right to do so through either electing new legislatures or ratifying the Constitution. So they punted it back to the voters of Idaho. All right, that's the background. Let's talk about the total abortion ban. The total abortion ban prohibits any abortion of a clinically diagnosable pregnancy by any person. It also prohibits assisting in the performance of an abortion, but the penalties differ somewhat. For if you're actually performing the abortion, it's a felony, up to 2 to 5 years in prison. If you are assisting, there's no criminal penalties that are associated with it, but you can have adverse licensure action taken against your license. For the first offense, it's a suspension of up to 6 months. For the subsequent offense, it's a permanent revocation of license. That adverse licensure action would apply both to those who perform or assist in the performance. The total abortion ban does have 2 affirmative defenses. First, if it's necessary to save the life of the mother and you perform that abortion in a manner that gives the fetus the best chance to survive, or in the case of rape or incest, if the physician, the patient actually reports that to the police and gives a copy of that police report to the physician. For purposes of the total abortion ban, abortion means the use of any means to intentionally terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination of those means will, with reasonable likelihood, cause the death of the unborn child. It does not include IUDs or birth control, birth control pills or things like that. And as interpreted by the Supreme Court, importantly, the definition of abortion does not include, under the total abortion ban at least, does not include ectopic or non-viable pregnancies. I'll talk more about that in a few minutes. I know a lot of practitioners were concerned by the definition of what is a clinically diagnosable pregnancy. The Idaho Supreme Court basically said, look, people know what a clinically diagnosable pregnancy is. It's been on the books. That standard has been on the books for about 20 years. During those 20 years, physicians have been required to report abortions of clinically diagnosable pregnancy, and there's never been any kind of challenge. They specifically said that the form of diagnosing the pregnancy, that's not really the issue. It doesn't matter whether you diagnose it clinically or chemically or whatever. The issue is just whether or not it's a clinically diagnosable pregnancy. Let's talk about those affirmative defenses. Remember that total abortion ban has two defenses. One, if the abortion is necessary to prevent the death of the pregnant woman, or in the case of rape or incest. Importantly, these are structured as affirmative defenses. They are not necessarily exceptions to the rule. So that has different consequences. If it's an exception to the statute, then there was no crime as long as you perform that. If it's an affirmative defense, however, and a person performs an abortion, they're still engaging in the criminal act. It's just they've got an affirmative defense or an excuse. The practical effect of that is that the burden of proof shifts, that if the prosecutor wants to prosecute somebody for performing an abortion under the total abortion ban, they can bring that action against the person. They could theoretically even jail them pending the trial. It's not until the trial that the physician or other healthcare provider would then be able to come forward and establish that affirmative defense of that the abortion was necessary. So there's been a lot of concern in the way that this was structured. That's something that you may want to adjust with the legislature. The Supreme Court specifically noted that a physician who performed an abortion as defined in the total abortion ban could be charged, arrested, and confined until trial, even if the physician initially claims they did it to preserve the life of the mother or based on a reported rape or incest. Only later at trial would the physician be able to raise the affirmative defenses available in the total abortion ban to argue that it was justifiable abortion that warrants acquittal and release. So the way that those defenses are structured makes a difference to physicians. Now, as a practical matter, it's unlikely that the prosecutor would ever pursue an action if it was clear that, or relatively clear, that the affirmative defense applied. But as Judge Windmill said in the district court case, that's cold comfort to physicians who are trying to make the determination about whether or not to perform or they're permitted to perform that abortion. When talking about those affirmative defenses, the first one is if it's necessary to prevent the death of the mom. The standard is actually the physician determined in his good faith medical judgment and based on the facts known to the physician at the time that the abortion was necessary to prevent the death of the pregnant woman. In addition to establishing that, the physician would have to establish that the physician performed or attempted to perform the abortion in a manner that in his good faith medical judgment and based on the facts known to the physician at the time provided the best opportunity for the unborn child to survive, unless in his good faith medical judgment, termination of the pregnancy in that manner would have posed a greater risk of death, of the death of the pregnant woman. No such greater risk shall be deemed to exist because the physician believes that the woman may or will take action to harm herself. So that is the first exception. Now, importantly, that necessary to prevent the death is a subjective test. You look at the subjective intent, the subjective judgment of that particular physician. It's not a reasonable physician standard. It's not an objective standard. You don't look at what other physicians would have done in that particular case. You look at the subjective intent of that particular physician. As the Supreme Court noted, this actually gives more protection to physicians than was held under the prior law. According to the Supreme Court, the statute leaves wide room for the physician's good faith medical judgment on whether the abortion was necessary to prevent the death of the pregnant woman, based on those facts known to the physician at that time. This is clearly a subjective standard focusing on the particular physician's judgment. The statute does not require objective certainty or a particular level of immediacy before the abortion can be necessary to save the woman's life. Instead, the statute uses broad language to allow for the clinical judgment that physicians are routinely called upon to make for the proper treatment of patients. So that subjective standard should provide some comfort to physicians, or at least it gives them some level of leeway. Now, whether or not how the prosecutor will interpret or apply that remains to be seen, but at least we've got that guidance from the Supreme Court that's helpful. The second exception is in the case of rape or incest, but in order for that to occur, there has to have been the rape or incest, and prior to the performance of the abortion, the woman or the parent or guardian has to report that act of rape or incest to law enforcement and has to have provided a copy of that report to the physician who's going to perform the abortion. In addition to that, again, the abortion still must be performed in a manner that in the physician's good faith medical judgment provided and based on the facts known to the physician at the time, provided the best opportunity for the unborn child to survive. That best opportunity for the unborn child to survive is based, again, on the physician's subjective good faith judgment, right? It's not an objective standard, not whether other physicians would have necessarily agreed with that. It's the subjective intent of that physician, which again is good news for the physicians. Now, that whole provision is somewhat weird because if you're going to do an abortion, the whole intent is to terminate the life of the child. So you wonder what in the world that particular requirement really means. At the Supreme Court, they acknowledge that it creates a textual difficulty, but they explained what was meant by, or at least their interpretation of what that statute or that requirement means. This means that if a woman is to have an unborn child removed from her body based on the preservation of her life, having been raped or the victim of incest, when the unborn child is viable outside of her womb, the physician must remove that unborn child in a manner that provides the best opportunity for survival. For example, vaginal delivery or cesarean delivery, and cannot remove the child using a method which will necessarily end its life, such as those. The exception to this is when, in the physician's good faith medical judgment, a method that would save the unborn child's life possesses a greater risk of the death to the pregnant woman. So again, that subjective standard is helpful. Now, as I mentioned earlier, as defined by the Idaho Supreme Court, the total abortion ban does not apply to ectopic and non-viable pregnancies. The way the court analyzed or got to that point is that abortions, of course, only apply to pregnancies. Pregnancies are defined as the reproductive condition of having a developing fetus in the body and commences with fertilization. The Supreme Court went on to say that for purposes of the total abortion ban, the only type of pregnancy that counts for purposes of prohibited abortions are those where the fetus is developing. In the case of ectopic pregnancies, when the fallopian tube, ovary, or abdominal cavity it implanted in necessarily cannot support its growth, we conclude a developing fetus under the definition of pregnancy in the statute does not contemplate ectopic pregnancies. Thus, treating an ectopic pregnancy by removing the fetus is plainly not within the definition of abortion as criminally prohibited by the total abortion ban. In addition, because a fetus must be developing to fall under the definition of pregnancy, non-viable pregnancies, that is, where the unborn child is no longer developing, are plainly not within the definition of abortion as criminalized by the total abortion ban. All right, so that ectopic pregnancy, non-viable pregnancy, those could be important exceptions that I know a lot of my clients have been concerned about. That gives them some comfort in that. I want to talk about the EMTALA exception real quickly. Now, David Wright covered that in the prior one, so I'm not going to go to it in a lot of detail, but I did want to touch base and remind you of the conditions for this EMTALA exception. The Idaho District Court held that the total abortion ban does not apply, or the government cannot enforce the total abortion ban if EMTALA applies. So the question is, when does EMTALA apply? In order for EMTALA to apply, there's basically 4 elements that have to be satisfied per the statute and the regulations. The pregnant woman has to come to the hospital or a hospital-based urgent care center seeking emergency care. EMTALA only applies to hospitals. It doesn't apply to other facilities, only applies to hospitals or hospital-based urgent care or dedicated emergency departments. Second, the woman or child has to have an emergency medical condition as defined in the regulations. Third, the abortion has to be necessary to stabilize the emergency medical condition. And four, the pregnant woman is not or has not been admitted as an inpatient or begun outpatient course of treatment. That's because EMTALA ends once a patient is admitted as an inpatient. EMTALA does not apply to inpatients. Even if you've got an inpatient who develops an emergency condition at the facility, EMTALA doesn't apply in that case. The hospital conditions of participation apply, malpractice may apply, but EMTALA would not apply in that case, and therefore the EMTALA exception to the abortion rule would not apply in those particular cases. The HHS in information that was put out after Dobbs came out stated, at least in its opinion, an emergency medical conditions that would trigger the EMTALA exception would include, but are not limited to, ectopic pregnancy, complications of pregnancy loss, or emergent hypertensive disorders such as preeclampsia with severe features. In the Idaho District Court opinion, Judge Windmill concluded that emergency conditions triggering EMTALA obligations might include ectopic pregnancy, preeclampsia and eclampsia, infection following rupture of the amniotic sac, elevated blood pressure or blood clot, or bleeding from placental abruption. Now, those are not all inclusive, but those are examples of the type of emergency conditions that would trigger the EMTALA exception. According to Judge Windmill, that the abortion must be necessary to avoid one of the following in order to justify the abortion: placing the health of a pregnant patient in serious jeopardy, a serious impairment to bodily functions of the pregnant patient, or a serious dysfunction of any bodily organ or part of the pregnant patient. HHS, in its guidance that came out enforcing EMTALA, for what it's worth, HHS stated that in making that determination, you look to what the physician thought was appropriate at that particular time. The course of treatment necessary to stabilize an emergency medical conditions is also under the purview of the physician or other qualified medical personnel. Stabilizing treatment could include medical and surgical interventions, such as those that are listed there. The key there, for those of you who are practicing in hospital emergency rooms or hospitals where EMTALA might apply, if you're going to rely on this EMTALA exception, you want to make sure that you clearly document the emergent nature of that, the patient's condition and the necessity of performing that abortion in order to stabilize the patient, i.e. one of those three factors there. EMTALA not only applies to the hospital where the patient shows up, it can also apply to receiving facilities. Under EMTALA, if a hospital has specialized capabilities, then it is obligated to receive a patient transfer from another particular facility. So it may be that we have a patient who shows up at a particular hospital. They need additional services, like maybe it's a critical access hospital or a small rural hospital that doesn't have the services that this particular patient needs. Then they can transfer that patient to a hospital with specialized capabilities. As long as that hospital has specialized capabilities and is not otherwise on divert, then that other hospital is obligated under EMTALA to go ahead and accept that patient transfer, which could include the obligation to accept transfers of patients who require an abortion. Now, it's important to note that that obligation to transfer the patient or to accept that patient transfer does not apply to inpatients. So once that patient's been admitted at a particular facility, EMTALA ends, not only for that facility, but for other facilities. So if you've got a transfer situation where there is a transfer of a patient who is an inpatient to another facility, the EMTALA exception would not transfer over to that other particular facility because, again, EMTALA ended at that particular point in time. At least that's the way we think it's going to play out because that's the way the EMTALA regulations read. When we're talking about the EMTALA exception, again, I want to emphasize that the district court's injunction is preliminary, not final. That case is still being litigated, so we need to continue to track that and monitor it to see how that EMTALA exception is going to play out. In addition, that district court's injunction only applies to the total abortion ban and would not apply in non-EMTALA cases. That the district court specifically did not address Idaho's separate fetal heartbeat law, including either the criminal penalties or the civil liability. I'll talk about that more in just a minute. Here, if you are a physician who's practicing at a hospital and you want to rely on the EMTALA exception, again, you're going to want to document those factors that show that EMTALA applies, including that the woman came to the hospital seeking emergency care, that that woman had an emergency medical condition, a specific condition that essentially jeopardized the life or the health of the woman. You want to document that the abortion is necessary to stabilize or resolve that emergency medical condition. You'll want to document that the patient's condition was not stabilized before the abortion, that the abortion was necessary to prevent the death or serious harm to the woman. And of course, you'll want to document the woman's informed consent or direction. And you'll also want to document to make clear that that pregnant woman was not, had not been admitted as an inpatient before that abortion was performed, nor was that patient undergoing an outpatient care when the emergency arose. EMTALA not only does not apply to inpatients, EMTALA doesn't apply if you've got a patient there who's already begun receiving an outpatient course of treatment and an emergency arises while they're receiving that course of treatment. If that occurs, then again, the government, at least under EMTALA, says that there are other statutes or regulations that apply in that situation, so EMTALA would not apply in that situation. So just make sure that that person was not previously a patient receiving that care or as an inpatient. All right, let's talk about the fetal heartbeat law or the 6-week ban. This is a separate statute. Remember, it was enacted after the 2020 total abortion ban, presumably because they didn't think the total abortion ban would ever take effect. So this was another way to try to regulate abortions, but it's still on the books. So under the fetal heartbeat statute, it requires any person who intends to perform or induce an abortion, they must determine if there is any fetal heartbeat except in a medical emergency. So this is an affirmative obligation. If you want to perform an abortion, you got to check and see whether there's a fetal heartbeat. Abortion is defined differently under this particular statute. This becomes important because it does not exclude ectopic pregnancies or abortions of non-viable children under this particular statute. I'll talk more about that a little bit later. In determining whether or not there is a fetal heartbeat is defined to mean as an embryonic or fetal cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. The statute says that a person may not perform an abortion when a fetal heartbeat has been detected, except if these conditions exist. If it's a medical emergency or in the case of rape or incest. In the case of a medical emergency, that means that the abortion is necessary to avert the death of the pregnant woman or substantial and irreversible impairment of a major bodily function of the pregnant woman. So unlike the total abortion ban that only allows abortions to protect the life of or save the life of the woman, the fetal heartbeat statute also allows abortions to, if there's a substantial and irreversible impairment of a major bodily function to the pregnant woman. Again, it also applies in the case of rape or incest, so long as that rape or incest was reported to the police and the physician is given a copy of that report. That fetal heartbeat statute has two different penalty structures. Okay, there's criminal penalties that apply to a person who performs or induces an abortion. Again, it's a felony, 2 to 5 years in prison. You can also be subject to those adverse licensure actions. Importantly, however, the fetal heartbeat statute, when it was amended, stated that if the total abortion ban takes effect, that those criminal penalties under the fetal heartbeat ban go away. So the net effect is the criminal penalties under the fetal heartbeat ban are trumped. They go away, they're preempted to the extent that the total abortion ban applies. Now that's going to apply in almost all cases except where EMTALA applies, because given the district court's opinion, the injunction, the total abortion ban is not effective. And therefore, according to the Supreme Court, because the total abortion ban is not effective, then the fetal heartbeat criminal penalties do become effective. So they would apply even in EMTALA cases. The district court opinion did not extend, the injunction did not extend to the criminal penalties under the fetal heartbeat statute. However, because the exceptions apply, then it's probably a situation where you don't need to worry about the criminal penalties. I'll come back and talk about that in just a minute. What we're most concerned about under the fetal heartbeat statute is the civil lawsuit. And under the civil lawsuit provisions of the fetal heartbeat ban, if there is that fetal heartbeat, if it's been detected and abortion's been performed improperly, then the mother, father, sibling, grandparent, or aunt or uncle of the child may sue the provider for $20,000 in statutory damages, actual damages, costs, and attorney's fees. So it allows for that Texas-style civil lawsuit. Now, in the Supreme Court decision, they made an important point, at least according to how they interpreted that $20,000 statutory damages was not meant to be as an additional penalty. Instead, they interpreted it as a compensatory damages. It essentially sets a minimum of compensatory damages, not duplicative or additional penalties in addition to actual damages. Instead, it's a minimum of the actual damages. So that is somewhat good news for providers. All right. So as I mentioned, the Supreme Court held that if in EMTALA cases, because the total abortion ban does not apply, that means the fetal heartbeat ban still does apply. However, the Supreme Court also noted that the fetal heartbeat contains the medical emergency exception. And that medical emergency exception is basically the same as EMTALA cases. So even though the fetal heartbeat statute would apply even in EMTALA cases, both of them have that same, essentially the same standard that allows you to perform the abortion to protect the life or the health of the mother. And therefore, it's probably pretty much a non-issue when it comes to the criminal abortion statutes. That medical emergency provision, though, is important, especially when it comes to the civil liability issues, both in EMTALA cases or in non-EMTALA cases. Under the statute, again, the statute accepts from the fetal heartbeat abortion ban any medical emergency which is defined as a condition that, in a reasonable medical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create a serious risk of substantial and irreversible impairment of a major bodily function. So that's the standard. Now, unlike the life of the mother standard under the total abortion ban, which was subjective, the standard in the medical emergency under the fetal heartbeat ban is objective. It's not a question of what that physician subjectively intended. Instead, the question is what a reasonable physician would do under that particular situation. The Supreme Court said this standard requires the physician to exercise reasonable medical judgment, kind of like in any malpractice case, when determining whether the medical condition of the pregnant mother necessitates an abortion to avert her death or avoid a serious risk of substantial and irreversible impairment of a major bodily function. Now, the good news is this medical emergency standard, it's an exception to the prohibition. So it's not an affirmative defense. The prosecutor would have to establish that the medical emergency did not apply. It's an exception, but when it comes to evaluating that medical emergency, it's an objective standard, not a subjective standard. The fetal heartbeat statute, unlike the total abortion ban, could potentially include ectopic or non-viable pregnancies. That's because the definition of abortion is different. At least according to the Supreme Court, the definition of abortion under the fetal heartbeat statute did not accept ectopic or non-viable pregnancies. On the other hand, the court still went on to say that we conclude that ectopic and non-viable pregnancies plainly fall within the medical emergency exception under the 6-week ban and civil liability. And therefore, if you're going to perform an ectopic pregnancy or presumably an abortion or a procedure on a non-viable fetus, at least according to the Supreme Court, that would trigger or be protected under the medical emergency exception. So the net result should come out the same, that you still should be able to perform those procedures for ectopic or non-viable procedures, at least according to the Supreme Court. There's also the exceptions for rape or incest. Again, the same standard applies. Unlike the total abortion ban, there is no requirement under either the rape or incest or the life of the mother or health of the mother that under the rape or incest, there isn't the requirement that the procedure be performed in a manner so as to optimize the survival of the child. I know that the civil liability statutes justifiably create a lot of concern among physicians, but just realize that those civil liability statutes are not necessarily new. They have existed for years under the 20-week abortion ban and the partial abortion ban or the chemical abortion ban. Under those, they allowed the pregnant woman to sue providers who violated those statutes. It's not clear whether the civil liability statute, the new form, the new version of that will supersede all of these other prior abortion bans. We'll just have to, or excuse me, these other civil liability statutes, we'll have to see how that plays out. Let's talk briefly about aiding, abetting, or assisting abortion. We know that you can't perform the abortion. What about aiding or abetting? Well, again, the total abortion ban states that licensed professionals who assist in a prohibited abortion, they can get adverse licensure action against them, but it's limited to licensed professionals because the only remedy is against those who, they can get their professional license taken away. So it's limited to limited licensed professionals. And there are no criminal penalties identified. This is different than the way the law used to be. Now, this is what the total abortion ban currently says. But there is another law in the books, Idaho Code 18-6061, which still continues to state that an accomplice or an accessory who aids an abortion in violation of 18-605 commits a felony and can go to prison for 1 to 5 years. The problem is the court has not, or the legislature did not address this particular statute, 18-606, when it amended or enacted the new statute. Note that this accomplice statute refers to a violation of 18-605. That's the prior statute that prohibited criminal abortion. Well, that's been superseded by 18-622. This accomplice statute does not refer to 18-622. So there's a good argument that it simply is no longer effective because the statute on which it's presumptively based no longer exists. And when the replacement statute was put in place, they didn't refer back to this statute. But we don't know exactly how that would play out. Similarly, it's possible that a prosecutor might use the general aiding and abetting statute to go after somebody who aids or assists in an abortion. But I think that's probably unlikely given the legislative scheme that they enacted when they did the total abortion ban, where they only provided for penalties against those professionals who assist in an abortion. So I think that probably the liability of those who aid and assist in an abortion is probably limited, but we'll just have to see. My general feel is as follows. It's unlikely a provider would be prosecuted for example, advising a patient of their care options, including the possibility that they could get an abortion someplace else, and either at a hospital under the EMTALA exception or in another state where abortion is legal. Nor would it probably be a violation or if they were counseling, transferring, or providing records to facilitate a lawful abortion at a hospital per EMTALA or in another state where the abortion is legal. I know a lot of providers have been concerned about that. Am I going to be prosecuted if I help this patient get an abortion in another state or under a circumstance where it's legal? I think that that's very unlikely. The theory is that, remember, at least as far as advising the patient of their options to get an abortion, Idaho requires informed consent. I mean, that's in the statutes, even in the abortion statute, you've got to get informed consent. That means, among other things, explaining the treatment options. And therefore, if you're explaining those treatment options, including the potential for abortion, that's appropriate and it should be permitted according to the existing statutes. In addition, if they tried to come after you for aiding or abetting a crime, well, if the abortion is being performed under a circumstance where it's legal, under the EMTALA exception, or in another state where it's legal, you're not aiding or abetting a crime. It's not a crime in those other states, and therefore you're not aiding and abetting a crime. It's possible that a prosecutor might try to hold you responsible here, even though it's not a crime where it's performed, but I think that that would raise serious constitutional problems. I've talked to several prosecutors on that, and they acknowledge that that would raise serious constitutional problems if we tried to criminalize something in Idaho, even though it's permissible in a state where it is actually committed, where it's actually performed, if it's legal there. What about talking points? What could you explain to the patient? Well, these are kind of my quick and dirty talking points. And by the way, all of this is summarized in a guidance document that I provided to you, that there's a link that I tried to provide some guidance to providers and medical staff members in dealing with these issues. That's in the materials that have been provided. Anyway, these are some things that I think you can do. Certainly, I think it's appropriate to discuss any information that's relevant to the informed consent, including care options and alternatives, risks, and benefits, including abortion. You could say something like Idaho law prohibits most abortions. However, if you have an emergency medical condition and go to the hospital may perform an abortion as necessary to stabilize your emergency condition. That's absolutely true and correct and lawful. That's an lawful abortion. That shouldn't be aiding and abetting. Or you may be able to obtain an abortion in another state where abortions are legal. You could tell the patient, if you want to transfer your care elsewhere, including to a provider who may perform an unlawful abortion, we will take appropriate steps to help facilitate your care, including transferring records, responding to questions, or facilitating an appropriate transport. I don't think there's anything wrong with that. You're just facilitating appropriate patient care that is lawful where the care is being taken. I don't think that you face much risk for that. You could also advise the patient that if they need more information concerning treatment options, including lawful abortions, you might contact and then give them the names of some people who contact. All right, in the interest of time, I'm just going to skip through a couple of these things. Remember that the new laws, the total abortion ban and the fetal heartbeat laws, are in addition to other laws that currently exist and have existed for many years concerning abortions. So those laws that have existed prior to this time still continue to exist, to the extent not inconsistent with the total abortion ban. So those other restrictions that exist in the law still apply to abortions, including some of those requirements for permissible abortions. So if the abortion is permissible, the Idaho statutes say that only a physician may perform an abortion, except maybe in EMTALA cases. During the first 13 weeks of a pregnancy, lawful abortions may be performed in a hospital or in a physician's regular office if certain conditions are satisfied. After 13 weeks of pregnancy, the statutes currently say that abortions must be performed in hospitals. Now, those foregoing rules likely do not apply to the termination of ectopic or non-viable pregnancies because, again, under that particular statute or interpretation of abortion, that would not extend to, according to the Supreme Court, that would not extend to ectopic pregnancies or non-viable pregnancies. There are other requirements that apply. I'm not going to go through those. Hopefully you've been familiar with those for some time period. One interesting point is the liability of pregnant women under the total abortion ban. It makes it clear that nothing in this section shall be construed as subject to pregnant women on whom any abortion is performed or attempted any criminal conviction or a penalty. Now, the problem is that says nothing in this section. That refers to section 18622, not the chapter. And if you look at other sections in the chapter, other sections in the chapter that are still on the books would make a woman criminally liable. I think that a court would probably state that the later statute, the total abortion ban, holding that the woman is not liable, represents the legislative intent, and therefore it should be honored, even though that other statute is still on the books, but it's something out there that needs to probably be resolved. In response to the Idaho action, as well as other states around the country that have now illegalized abortion, the government has been taking certain action, including establishing a new website talking about fetal rights and the like. They've made it easier to prescribe, for pharmacies to prescribe certain abortifacients. They've given guidance to pharmacies that warn them of discrimination if they fail to carry those abortifacients just because they may be used for abortions in addition to other services. The bottom line there is none of those do anything to legalize abortions that are otherwise illegal in Idaho. So That's the state of where we're at. The Supreme Court basically said, look at Idahoans, if you don't like this, the law as it is, then it's not our responsibility. We don't have the authority to change that law. As long as the law is not unconstitutional, it's not unconstitutional. Therefore, if you want to change the law, you as the voters, you have a couple of options. You could either get your legislators to make the change, or you can ratify new constitutional changes. But basically, the Supreme Court has put that obligation back on the voters. So that brings us to the issue about where we are. I thought that I would turn some time over to Liz to see if you can give us kind of an update of what's going on at the legislature and what the potential ramifications are and what might happen.
Thank you so much, Mr. Stenger. That was an excellent presentation. Really appreciate it. And just briefly, in the interest of time, so we can get to the Q&A, I'll share that there will be an effort in the legislature to provide clarifications to the laws to make it easier for physicians to practice standard of care and keep patients safe. Expected legislation in either one or more bills will address exceptions for life and health of the mother, and rape and incest and fetal anomalies. There will be an effort to remove the requirement for a police report for rape and incest. There will be an effort to provide actual exceptions in lieu of the affirmative defense currently within the law. And there will be an effort to roll back the bounty-style civil lawsuit provisions. These, as I said, may come in one or more bills. Of course, there will be opposition to this effort, and there will likely be legislation that tries to take away the exceptions for rape, incest, even with a police report, and life of the mother. So we expect to see a dialogue between efforts to clarify the law and efforts to make the law more stringent. There have been a couple of pieces of legislation already introduced in the legislature. One of those which did not move. It already was dismissed. There is a piece of legislation that attempts to redefine the meaning of abortion that may move. And of course, legislation that is being supported by the IAFP will be tracking other bills that are introduced and try to address kind of the scope of what needs to be addressed during this session. So I think that's all I'll share now in terms of the interest of time. But happy to take questions in the chat. And very briefly, I'd like to ask Dr. Kylie Cooper to share any clinical comments before the questions. We also do have activity in the chat with some comments on clinical implications, which you may want to refer to Dr. Cooper, or I can raise and address after you speak. Please go ahead.
All right, well, thank you, Mr. Singh. I really appreciate all of your work in deciphering and interpreting where things stand legally and how this may apply in a practical sense. I think that while there still remains some uncertainty in how these bans and the penalties will play out in the real world, I think this has been really informative. And as you alluded to, as a clinician, I think one positive that's come from the decision are the statements about ectopic and non-viable pregnancies. So while the restrictions and penalties and affirmative defense still apply to those cases of abortion, for those patients experiencing ectopics or pregnancy loss, as well as their providers, I'm hopeful that some of those barriers to care can be removed following these statements. So let me see if there's questions here.
So we just have a couple comments right at the top of the chat, which I can read and let you react to, either of you react to. So Dr. Corrigan shared that it would be malpractice to perform a C-section at less than 21 to 22 weeks, unless it is for a failed D and E catastrophic hemorrhage. So she's saying that I think one of the statements in the law doesn't make any sense medically. Also, she's shared revising the term to say in utero, as the new proposed bill does, may still be confusing, as a C-section scar or corneal ectopic may be interpreted that those implantations are technically in the uterus. Any reaction to that, Dr. Cooper or Mr. Stenger?
Yeah, I have to refer to the doctors on that. Defer to the doctors. That's all clinical stuff.
Yeah, I mean, this standard of care should still apply. So I would agree with, doing a cesarean section for a non-viable pregnancy, unless that's the absolute, last resort, would not be appropriate. So doing your standard medical and surgical interventions. And then I would agree with the statement about, the verbiage of in utero. I think that, medically there are ectopic pregnancies that are within the uterus, and so I would agree that's kind of a gray area as well, how that would actually, play out.
And then just to share with the group who may not be monitoring the chat, Dr. Corrigan shared that SMFM, which I'm assuming is the Society for Maternal and Fetal Medicine, is going to be putting out further guidance on treatment of pre-viable PPROM in the next few months. So thank you for sharing that, Dr. Corrigan. She also shared the federal government also says you cannot abandon the patient. You have to continue the planned course of treatment if the patient happens to get admitted. Any comment on that, Mr. Stenger or Dr. Cooper?
That is true, that you can abandon the patient, but once the patient's admitted, then I think that even David Wright confirmed that EMTALA ends, as long as you're admitting them in good faith. Now, if you're just admitting them to send them someplace else or something, that wouldn't apply. But once they're admitted in good faith for EMTALA defines admitted, then EMTALA ends, and the EMTALA exception, at least is currently structured by the Idaho District Court, would end, and therefore you wouldn't have the benefit of that exception.
Then there was a question about the statute of limitations on the civil charges, and Peg Dougherty actually answered this in the chat. It's a 4-year statute of limitations.
Correct.
And Dr. Corrigan commented that the only lawsuit filed under the Texas law in over 1 year was thrown out by the court. Any comment on that, Mr. Stenger?
I haven't followed the Texas statute, so I don't know. It doesn't surprise me.
And then the next question, what about translating for a patient calling an overseas hotline for abortion pills by mail prescribed by a provider out of the country? How would that be viewed under the law?
I would be perhaps a little bit nervous about it. I don't know. Would we have a situation where our providers are actually translating for those situations? I think if I were the provider, I might put them in touch with another translator and let them handle it, but I'm not sure that I would get involved just because I don't want to get into that kind of sticky wicket.
There was a request for a list of, quote, clear statements, actual do's and don'ts that can be used currently. I don't know that we have that developed yet, although there are a lot of different organizations working on resources. Mr. Stenger, do you have any comment on that request?
I know a lot of the facilities have come up with certain guidance. I know one of the documents that I provided to you attempted to give some guidance for medical staffs that walk through the specific requirements, the exceptions to the rules, and statements that are probably safe, what you can do and what you can't do.
Great. And the resource list with the links that Mr. Stenger is referring to has been shared in the chat twice, so you should be able to find it there. I'll put it in after the Q&A as well again. We have a comment, EMTALA exceptions. One of the requirements is emergent conditions did not emerge while undergoing outpatient care. What does this mean for pregnancy of unknown location or ectopic pregnancy being followed in clinic?
I don't think that it would apply in those particular situations. I think that what they're talking about, the example that they give in the EMTALA commentary and the interpretive guidelines, if you have a patient who comes in and who's undergoing a cardiac stress test as part of an outpatient procedure, and in the middle of that, they have a heart attack and fall over, EMTALA would not apply in that case because under EMTALA, that person has already come to the hospital, they're already a patient. Therefore, you don't need EMTALA, you've got conditions of participation and other things. So that's the type of outpatient procedure we're talking about. That might apply. I suppose it could apply if you have a maternal patient who comes in for some kind of stress test and they're in the middle of some kind of stress test and an emergency occurs. I suppose it's possible it could apply in that situation, but unfortunately we haven't got any specific guidance from CMS on that interpretation or application in that context.
Thank you. And I have dropped the full resource list link, which has a variety of other links that Mr. Stenger has referred to, back into the chat. I don't see any other questions or comments yet, so I would invite those of you participating to type in any additional questions, clarifications, or comments into the chat. While we wait for that, Dr. Cooper, is there anything else in terms of everything I've just covered you'd like to comment on?
No, I just really appreciate everyone's time and discussion.
Oh, here's another question. How does one lawfully care for a partial molar pregnancy? Heartbeat present, so quote unquote viable, except will not result in normal baby.
I think that's a very tricky scenario because if it's not considered non-viable, if there is a developing fetus, I don't know that that would fall under the ectopic or non-viable pregnancy. I
Yeah,
don't know, Kim, you have thoughts on that one?
yeah, I agree with you. I think that in the past legislation, when they passed this, the legislature, specifically ruled out an exception that would apply to severe birth defects or anomalies. So I think a court under the current scheme would say, if it's viable, even though it's going to suffer severe defects, then it's still, the abortion rule would still apply to it. The legislature may change that going forward, but that's kind of where we're at right now.
Yes, and thank you both for your comments on that and for the question. This is absolutely an area of the law that urgently needs to be clarified, and efforts in legislation will try to address this, and then we'll see what the outcome of that is in the legislature. But this is absolutely one of the areas that is complicated under the law. We did have another comment. However, molar pregnancy increases risk of GTD to mother, so can interpret as risk to mother's life or health. And then another comment, molar pregnancy can also cause thyroid storm and make mom profoundly sick. Any other thoughts or comments based on those reactions?
I might just jump in there. I mean, if that woman is having those conditions in an EMTALA case, then it sounds to me like the EMTALA application may apply, the exception may apply. If they're not, if they're just in the physician's office having that, then EMTALA exception might not apply, but I don't think there's anything inappropriate in telling that patient that look at these are your treatment options. I can't do that. But if you were to show up at the ED with an emergency condition, then they have the ability to do that I don't. So, I think you could potentially arrange, or that patient could go to the ED and get that alternative care.
Yeah, and I would agree with that as well. If someone comes into the ER with thyroid storm in that scenario, or they're having a hemorrhage or other, life-threatening complications, I would agree with your statement as well that you could probably proceed under the EMTALA protections.
And we did have clarification in the chat that GTD is cancer, and some, frustrated comment about having to wait until a mom gets really sick. And obviously this is, the EMTALA exception is trying to address that, but the laws in Idaho are creating a problem in that respect, and that's something that really does need to be addressed. I know that we met with a senator yesterday who felt that the law as written provides an opportunity for a doctor to sort of forecast death across time, but that's clearly not specified into the law. So that is really an area that does need to be clarified. And
we
then,
did.
Oh,
could
sorry.
I interrupt just for a second?
Yes.
There was helpful language from the Supreme Court, though. They did say that when you're talking about the life of the mother exception to the total abortion ban, remember it's a subjective test. And they do talk in terms of, there is no requirement for any particular immediacy. So so it's not like there's a test that if she's going to die in, in 3 months or something like that. I think that does give you some window, but maybe that's cold comfort from physicians who are afraid of misstepping.
We have another question, multiple IVF pregnancies, 4 or more fetuses, what do we do? And a comment about that, I think all fetal reductions are usually done out of state anyways, Seattle, San Francisco, correct, Dr. Cooper?
Yeah, I would say that would have to go out of state for that kind of care.
And then another question, what do you believe will be the position of our Idaho Attorney General on these issues? Mr. Stenger?
Oh boy, I kind of hate to answer that one, but we've got historically a very conservative Idaho Attorney General who came out and very much in favor of the Supreme Court case, the Idaho Supreme Court case. So I don't know. I guess it remains to be seen how active they will be in addressing these particular issues.
Yeah, that's definitely an area that we're all kind of waiting to see how it's addressed, but feel that some of the complications and issues that physicians are facing may not have a sympathetic ear in the Attorney General's office. There's some thank yous coming in. Any other final question? I can take maybe one more. Just more thank yous.
Just can I just make one comment about that? Remember, it's not just Raul, right? It's local prosecutors also, and any local prosecutor could presumably decide to prosecute this. I think the vast majority of them are reasonable. They're not going to want to spend time or money on a high-profile case that's going to get a lot of attention and perhaps a lot of scrutiny and cost a lot of money. So I think most of them will probably would apply this in a reasonable case. But I suppose it's possible that you might get some politically motivated prosecutor out there who wants to make a name for themselves who might decide to take this on. That's the risk, I think. That's probably what scares me the most.
There is a question about recourse against malicious prosecution.
That is very difficult to establish. In fact, the civil liability statute you have to do certain things as a physician in order to even recover your own fees and costs in the case. You have a higher burden to recover your fees and costs than the patient does to recover their fees and costs. So I think it would be pretty difficult to establish, and you better make sure your ducks are in a row before you start down that path.
Well, thank you very much. Please direct any further questions to Mr. Stenger via the email address shared on the slide in front of you. Thank you, Mr. Stenger. Thank you, Dr. Cooper. As a reminder, we have recorded this presentation. The Holland and Hart team will be providing that to attendees, and the IAFP may be doing that also. Know that the Idaho Academy of Family Physicians, the Idaho Medical Association, and other partners are actively working to provide clarity in the law. We know that these provisions and the confusion that they're creating has a chilling effect. It's cold comfort to hear that a prosecutor may or may not, when you're in the midst of making a decision that could face prosecution. We know that that's not good for physicians, other healthcare professionals, or your patients. And we are going to be doing everything we can to provide a broader scope for you to be able to do your practice and keep patients safe. Again, thank you so much to Dr. Cooper for your time today. Thank you so much to Mr. Stenger for putting together this important presentation. Any other comments from either Mr. Stenger or Dr. Cooper?
Thanks for all you do.
Okay, I'm going to leave the chat open or I guess I'm not doing it, but I will sit here for a minute or so in case there's any questions or clarifications that come into the chat that need to be noted. But otherwise, thank you so much to everybody for your time today, and stay tuned for a recording. So Charles, if you're still there, I think we're good. Is there, I'm just, wanting to keep that chat open in case anything important comes through. Any final tying up loose ends here or comments?
Just whenever you're ready for me to end the meeting, I can do that. Just let me know.
Yeah, I think we're good. And actually, I'm so sorry. I met with Luke yesterday. I just can't remember. So will you all send